I want to start this video out by saying all constitutional rights invoked, none waived. Getting right into it. We will be putting on blast some domestic terrorists, okay? Domestic terrorists are defined by people who go against the Constitution intentionally and who refuse to uphold the rule of law with regards to the U.S. Constitution and or their respective state constitution. Getting right into it. This is a violator of 18 U.S.C. 241. In 18 U.S.C. 242, his name is Jess A. Lorona, and he is affiliated partner with Lorona and Me, personal injury, criminal defense, and family law. This was the judge in my eviction trial, okay? Now, for those who haven't been following along, I had a property management company try to file a fictitious eviction against me after receiving nearly $30,000. What they did was they tried to create a narrative that I was starting a GoFundMe to pay rent, in which that was false. And guy right here was the trial court judge, and we're going to get into the role he played, and we're going to get into what happened to him, and we're going to get into where things are today, and we're going to be showing proof. We're going to be showing the case dockets and everything. So this is Judge Lorona, so you guys have a picture of him. This is Judge Lorona, okay? Okay. All right. This is the slime ball. Okay. All right. Now, the next clip, we're going to get into what he did. We're going to be looking at the court docket. So I'm going to stop this little clip right here, and the next clip is going to punch in. Okay, we're back into it. We typed in Dreamy Draw Justice Court Judges Phoenix, okay? And we got Dreamy Draw Maricopa County Justice Courts. Okay, we're going to click there. Okay, so if you guys want to follow along and get your screens ready and put this in your screens, you can do it too. We're going to click on that. Okay, and we're going to go to find a case. Find a case. You're going to go to case history. You're going to go to McCormick, Mark, and you're going to put search. You're going to find the case number that says CC 2021-169905, and you're going to click on that. That's going to take you to the case that is currently pending, okay? The case that is actively open right now in the appeals court. Okay, now let me go ahead and tell you guys what you're looking at, okay, because you have people on the internet that want to try to manipulate. So we're going to clarify some things and let you see what you're looking at. Now, if you go to the top, you see case information and you see case number, you see Judge Conti Frank, and you see the file date was 10/21/2021, location Dreamy Draw Justice Court, case status adjudicated, case type justice civil. Okay. Now, you go see the parties information, which these are the parties that I sued in the Superior Court, which is a different court than this court. Okay. The Superior Court is a different court from this court right here. Okay. Now, if you look at the case calendar, you will see that on 10/28/2021 at 1:30, an eviction hearing was set for trial. Okay? The trial took place November 4th, 2021 at 2 o'clock was a trial. Okay? And there was a judgment that was put in. Okay, that judgment was put in by Judge Jess A. Lorona. He was the judge that overseen the eviction case. He was the trial court judge, and he was the trial court judge that committed federal crime under 18 U.S.C. 241 and 18 U.S.C. 242. Why? Because he intentionally blocked my evidence. He intentionally violated the 14th Amendment's Equal Protection Clause. Equal Protection Clause violation was because he allowed the plaintiff to enter in their evidence, and he did not afford me the same equal protection under that law by allowing me to submit my evidence. What he did was he blocked my evidence, and he lied and said it was never received, and it was. He had a chance to look at my evidence, and he knew that based off of my evidence that the case would not have been able to come to a final judgment for the amount that they were seeking. So what he did was he lied intentionally and said he never received my evidence, okay? Which it has him in very, very boiling hot water right now. Okay, now let's look at the events here, okay? Let's look at the events. I immediately filed a notice of appeal, okay? And the waiver of my fees was granted. The courts waived all of my fees, and they granted that waiver on November 16th. Okay. Now let's talk about this next Let's talk about this next thing that says ruling on motion. Okay. Denied November 16th, 2021. Now one might say, well, Mark, what is that? What got denied on November 16th? What motion got denied? Okay. The motion that got denied, the denial of the motion is on our community post, okay? And that motion that got denied was the plaintiff's motion to uphold the judgment, okay? And for their writ of restitution. Their writ of restitution was not granted because they committed a federal crime, okay? They were pulling a scheme with all of this eviction stuff, all right? Now, as you can see, the case has not ended, okay? The appeals case is not ended, okay? All right? So let's go back over here to the result dates. And let's look at the notice of appeal was filed November 8th. Okay. Now, the last thing that was filed was my appellate memoranda, which was filed January 5th, 2022. Okay. A little bit more than 2 weeks ago. That was the last thing that was filed on this case. All right. So this case is currently open, active, and moving forward. And there was not a final judgment in the eviction. I was not evicted, and I left the property under my own authority because they were trying to pull this scheme, and I knew they were going to get caught because I had everything to prove that they were pulling a scheme. So now that we got that out the way, now that we know that there was no eviction that was successfully adjudicated towards Mark McCormick, okay, and since we know that their motion to have the sheriff come and evict me and to uphold their judgment was denied on November 16th, okay, so that gets that all out of the way, okay. Now we're going to move on to the next little mini clip. Okay, now let's talk about the next individual. This is Miss Shauna Murphy Warner, okay? This is the attorney that the defendants XCD Realty, the Shaw Family Trust, and Anthony Masiello hired. Okay, this is the attorney that they hired, okay? And I think she's been practicing more than 30 years. Here's some of her background here. Shauna joined the predecessor firm as a law clerk in 1988 and was invited to become a partner shortly after admission to the bar in 1989. While all partners of the firm provide services in all aspects of civil litigation, Shauna's strength and passion are in those cases involving catastrophic personal injury or death, complex motion practice, mediation, and appellate work. Shauna has earned the respect of clients and colleagues by passionately and vigorously advocating for the client's cause without ever losing sight of the objectives of our justice system and while maintaining steadfast adherence to the lawyer's creed of professionalism. We'll see about that. Okay, I can't read no more. My stomach is hurting. Okay. Let's stop some deception today. Okay. Now, I want you guys to listen to these next words that I am about to say very carefully. And I want you to look at this individual in this picture. Okay. And I want you to listen to what I'm saying to you. Now, we already seen who Judge Jess A. Lorona was. And we already went to the Justice Appeals Court docket. So this is what you guys know. So everybody who's been watching this video from the beginning, what you know so far is you know who Jess A. Lorona is. You know what he looked like. And you know that his judgment that he put out against me was not upheld. And you know that I appealed his judgment. You know that he violated 18 U.S.C. 241 and 18 U.S.C. 242 under federal law. And he violated the United States Constitution's 14th Amendment. And he violated the due process clause of that 14th Amendment and the equal protection clause of that 14th Amendment. Okay? Now, one might say, well, Mark, what are you talking about? Why is that relevant to, and why do you have us looking at this lady and her beautiful smile? Well, we're going to get into that right now. Okay. Now, this lady filed an answer on behalf of those defendants. Now, since we know that there is an appeal and that there was not a final judgment, let's look at the answer that this lady filed. We're going to look at the answer that she filed with the courts. Okay? We're going to look at the answer that she filed with the courts. But wait, hold on. Let's scroll down and let me read something again. Let me read something again down here. It says, Shauna has earned the respect of clients and colleagues by passionately and vigorously advocating for the client's cause without ever losing sight of the objectives of our justice system, and while maintaining steadfast adherence to the lawyer's creed of professionalism by demonstrating and demanding the utmost respect for all those in the litigation process. Okay. Now, what we're going to do is we're going to take a look at the document that she filed. Okay, people, this is the document that was filed by Miss Shauna Warner with the beautiful smile. Okay, I want you to look at this. Let's start at the top. Okay, this is the same name that was on that website I just showed you guys. Attorneys for Defendants Shaw Family Trust, XCD Realty and Property Management, and Anthony Masiello in the Superior Court of the State of Arizona in and for the County of Maricopa. Okay, this is the defendant's amended answer to the plaintiff's complaint. Now, I'm not going to scroll through all of this. I'm not going to read through all of this because I don't expect for many of you to understand what's being read here, okay? But we're going to look at a special part, okay? We're going to look at a special part. Okay, let's look at statements of facts in breach, okay? Let's look at that, all right? Let's look at that. Actually, no, we're going to skip that. Let's look at the affirmative defenses. Okay, affirmative defenses are defenses that the defendants are going to assert at trial. They have to tell what their affirmative defenses are going to be up front in their answer. Okay. All right, let's look at this trash. Okay, affirmative defenses. Ask for a separate and affirmative defense, and in the alternative, these answering defendants allege and assert collateral estoppel and res judicata, as the courts have already determined that plaintiff was in breach of the residential lease agreement, failed to timely pay rent when due, and that judgment is final and non-appealable. That is a lie right there. We all know that the judgment got appealed. The upholding of that judgment was denied. Okay. Was denied November 16th. Okay. Now let's keep on moving forward. All right. B. Ask for a separate and affirmative defense, and in alternative, these answering defendants allege and assert that plaintiff's complaint fails to state a claim upon which relief can be granted, which also is a lie. C. Ask for a separate and affirmative defense, and in the alternative, these answering defendants allege and assert that plaintiff's injuries and damages, if any such damages exist at all, were caused in whole or in part by plaintiff, representing comparative fault or by a third party over whom these answering defendants exercise no control, and defendants expressly reserve the right to apportion fault to any such non-party as supported through discovery. D. Ask and for a separate and affirmative defense, and in the alternative, these answering defendants allege and assert that plaintiff's complaint fails to conform to the Arizona Rules of Civil Procedure, Rule 8, requiring a short and plain statement of the grounds for the court's jurisdiction, and a short and plain statement of the claim showing the plaintiff is entitled to relief. E. Ask and for a separate affirmative defense, and in the alternative, these answering defendants allege and assert accord and satisfaction. F. Ask and for a separate affirmative defense, and in the alternative, these answering defendants allege and assert failure of consideration. G. Ask and for a separate and affirmative defense, and in the alternative, these answering defendants allege and assert statute of frauds. H. Ask for a separate and affirmative defense, and in the alternative, these answering defendants allege and assert waiver. Ask and for a separate and affirmative defense, and in the alternative, these answering defendants allege and assert failure of service of process or ineffective service of process. J. Ask and for a separate affirmative defense, defendants allege and assert that XCD Realty and Property Management and defendant Masiello are licensed professionals, and as such, plaintiff's complaint fails to comply with ARS 12-2602, requiring an expert affidavit. Oh, so now we have to have expert affidavits to invoke a First Amendment right to redress? I don't think so. And K. Ask and for a separate and affirmative defense, and in the alternative, these answering defendants believe that further affirmative defenses may be applicable, which may be presently unknown. Defendants reserve the right, therefore, to further amend their answer to assert further affirmative defenses upon the completion of discovery. All right. Now, let me tell you the problem with this document. Okay, the very first problem. The very first problem is Part A. Ask and for a separate and affirmative defense, and in the alternative, these answering defendants allege and assert collateral estoppel and res judicata, as the courts have already determined that plaintiff was in breach of the residential lease agreement and failed to timely pay rent when due, and that judgment is final and non-appealable. Now, didn't I just go to the appeals court docket and show you guys that this appeal, that that eviction was denied, and that the writ of restitution was denied, and that there was an appeal filed November 8th, and that a memorandum for that appeal was filed January 5th of 2021. So what is this? What is this? What is this? This is trash. This is garbage. This is what I have been dealing with in all of these courts in the last 6 years. This is what I've been dealing with. Paper gangsters who are not honest and who are not filing things after doing their fact-finding investigation. Now, if what she says is true in her affirmative defenses in her amended answer, why is it that we just went to the appeals court docket and we just seen that there is an active appeal? The situation was appealed. The defendants did not. They absolutely did not get final judgment rendered. Okay? So let me tell you what we think this lady did. She looked me up. She seen this copper skin. Okay? She heard some defamation about me. And she said, okay, this is what we're going to do. She didn't bother to go look at the facts. And this is what a lot of these attorneys and a lot of these legal judicial people have done in the past. They listen to the defamation without doing a fact-finding investigation. And see, this is why Moses is going to get justice. This is why I'm going to get justice, because we follow things by the book, how it's supposed to go. This, with this lady, this is why she was removed, probably, I'm assuming. Because she was removed. She's no longer their attorneys. She's no longer their attorneys. And she's no longer on the case. She's no longer their attorney and she's no longer on the case. But this answer that was filed on behalf of these defendants, this answer is erroneous, okay? So we're going to let the record reflect and take notice of that. Now that we got all that out the way, let's talk about something else. Let's talk about this investigation. Now, what we have learned through this investigation is everything that we already knew, okay? We already knew. What they did was certain people in the background have went above and beyond, okay? They sabotaged our GoFundMe, okay? They tampered with many of our different websites, okay? They tampered with many different streams of income that I have, okay? And one might say, well, why would they tamper with your different websites? Why would they tamper with your different streams of income? We're not going to get into how, but the reason why they did that, because they really needed the public to believe that I was evicted from my house and that I was only doing a GoFundMe to come up with rent funds, which got this judge, Jess Lorona, in big serious trouble, okay, and has gotten many other people in trouble, all right? And these handlers behind the scenes have been controlling these courts for many, many years, okay? They have been controlling courts. They have been controlling departments of insurance. They have been controlling a lot of different things, okay? A lot of different things they have been controlling. And now we are living in a time where we can actually see these things playing out. We can see all of these things that were rigged. We can see all of these unbelievable things that are shoved down our throat, and we're trying to be forced to believe, forced to believe it. We're seeing a lot of things, and then we're being told not to believe what our eyes are telling us, okay? So it is very, very important to pay attention to not only the facts, but pay attention to circumstance as well. Okay? And pay attention to totality. Okay? Now we all know that Moses was murdered. I don't have nothing to gain by alleging that my brother was murdered. I would have been honored to say, okay, he died of heart complications, but that's just simply not true. Okay? And the bad guys, they did not know that I had those photos showing that he was beat up. They didn't know that. Okay? So when I told the public that I had that, they used certain trolls to say, oh, no, he doesn't have any photos. And when I presented the photos in the video, what did they do? They tampered with the views on the video. They faked the views on the video to make it seem as if only 40,000 people watched it. Okay? They faked the whole narrative that they came up with. And these are the same people that forced Moses to record those 2-hour videos under the direction of his handler, which was Language Bay. Okay? And you can see a consistent pattern of that, with people still uploading 2- and 3-hour videos that they are trying to somehow convince the public that, oh, that's not what's happening. These are the same group of people that are behind the killing. These are the same group of people that are behind getting Judge Lorona in the trouble he got in. Okay? These is the same group of people who rigged the courts in my situation in the past, and who's rigged it in many other people's situation in the past. And this is a beautiful situation to bring awareness of all the rigging that goes on in this country. All of the rigging of everything. Okay, we done seen things rigged from people's school grades to admissions in universities, all kind of things. You think of it, you can name it, it's been rigged. Okay? So if one might say, well, you've been in a lot of these court cases, a lot of those court cases were violating the Constitution, which is fact. Okay? And a lot of that practice is common practice in Ohio courts. That is why when Moses and I filed the RICO suit, we filed it in Arizona federal courts, because Arizona courts are a lot more fair than Ohio, because Ohio, they do not honor the United States Constitution, and they don't honor their own state constitution. Okay? Because under the Ohio state constitution, there is a law that makes indoctrination illegal in the state of Ohio. And clearly, thousands and thousands and thousands and thousands of people have been indoctrinated in their little school systems in there, okay? So that would mean thousands and millions of people have a lawsuit against the state of Ohio because they violated their own constitution for indoctrination. Okay, so we're going to leave that there. But getting back to all of this rigging, Ohio is notorious for rigging. Okay, that's why we don't trust nothing that comes out of Ohio. We don't trust nothing that comes, nothing legal that comes out of there. They steal. Okay, I've seen cases where people who had inheritances left to them, and it's pulled through probate court, and it's all stolen. That's Ohio for you. So the only heart complications there ever was in this investigation, what this investigation has proven, is the only heart complications it ever was the fact that Ohio is the heart of our country. Okay? Ohio is the heart of our country. Okay? Ohio is the state that is the heart of our country, and that is the only heart complication that is ever viable in this situation. That's the only heart complication that there has ever been in this whole entire situation, was the fact that Ohio is very corrupt, okay, and that they practice judicial terrorism on a day-to-day basis. They use judicial components to terrorize men, create deadbeat fathers, remove men from the household that has children, in the whole gamut. Okay? Now we're going to end this video because we're not going to make it all drawn out. And part 2 will be coming out within the next week. All constitutional rights invoked, none waived.